Every day in the USA, people find themselves in court.
Sarah Amadon versus Evan Moon, case number 39434. I'll go ahead and call that one right now. And Ms. Amadon, I see you're appearing remotely on Zoom. Good morning. And I just want to
Good
confirm
morning.
morning. Is anybody here for Evan Moon in court or on Zoom? Okay, I'm not
It's
seeing it.
Aaron Moon.
Aaron Moon. Okay. Sorry, it printed out as a typo on my page here. So is anybody here
Okay.
for Aaron Moon? No? Okay, thank you. So it looks like we have a certificate of service that was filed. It's signed and it's claiming personal service on Aaron Moon on January 1st, 2026. So I'll find that there is appropriate certificate of service. And oh, this was the one that gave me the creepy crawlies when I reviewed the file yesterday. Okay. So I reviewed the evidence. So Ms. Amadon, because you're the only party appearing, the court will consider entering a default judgment. Before we do that, I just need to swear you in and get the very basic facts from you and evidence of the amount of damages. And so with that information, the court should be able to enter a default judgment. If you could just raise your right hand. Do you swear the testimony that you would give the court will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. So you've been sworn in. We have proper proof of service. And I saw that you had basically sent the defendant an invoice for about double what you're asking for. They'd paid some of it. So can you just, again, for me, just describe very quickly how much is owed and why?
I think I'm confused on what you said, double for what it's asking for. So the original cost, hold on, I have to pull I'm so sorry, I'm not as ready as I thought I was. All right, so the original cost came to 12, came to $1,225.
Right.
They only paid half of that. And so sometimes when I go to a client's home, rarely, this doesn't happen often, but rarely the family can't afford the price because it is quite large. And it's large for a reason. Lice, getting rid of head lice is not easy. It's a lot of hard work. And so for certain families who can't afford it, we do a sort of payment plan for the families, but then of course they have to put in writing that they will pay it, how they'll pay, and how much they'll pay. It doesn't have to be exactly down the middle like they did. That's something they chose. I'm okay if someone wants to pay me $50 a month as long as it gets paid. But that's what they chose, was $612.50 to split the payment down the middle. And the first payment was not paid on time, and the second payment wasn't paid at all. So
okay, thank you. I understand. So the remaining balance is $612.50. Is that right?
Correct.
Okay, thank you. And you had to pay a $50 filing fee to file this small claims lawsuit?
I did.
And then did you have to pay to have service of process done?
No.
Okay. So I will make a finding based on your testimony and that there is liability here by the defendants. And I find sufficient and substantial evidence of the damages of $612.50. And so the court will award you that amount in the judgment, as well as the $50 filing fee. And we'll just fill out that paperwork and it'll be in the court file for you. Do you have any questions for me?
I do have one question. So now that it's been in my favor, how do I get Erin Moon to pay me what she's owed me.
So, excellent.
Oh,
We're getting some feedback. Okay. So the court cannot give you any legal advice on how to collect on the judgment. You'll have to do some research and talk to some people on your own on that, but you will have a judgment that you can try to act on.
okay. So like if it's in contempt, then I come back to court. If they don't pay, I mean, then they're in contempt and so on. I'll get legal advice.
All right. Yeah, as I said, I can't answer your questions on that matter, but I do appreciate your testimony here today. I'm sorry you had to come in to do this, and we'll get this signed for you.
All right, thank you.
And if you could just bear with me while I sign it in case I have a last minute question.
Of course.
Okay, here's that for you. All right, so that order's been signed, Ms. Almadon, and you're free to go. Have a great day.
Thank you so much.
39344, Carrie Peterson versus Expedia Group. It looks like the parties entered into mediation and that did not succeed, and the parties are requesting to go to trial. Mr. Peterson, I see you're with us on Zoom. If you could turn on your camera and unmute. Good morning, sir. How are you?
I'm doing as much as the Almighty allow me to do. How about yourself?
Good morning, and Ms. Abreu, good morning. Can you both hear me okay?
Yes.
Okay, so what's going to happen is we're going to have a trial, a small claims trial, and the court will hear from both parties. What tends to happen in these proceedings is that one side will get upset about what the other side says, and that's understandable. But even if that happens, the court orders you to not interrupt. Everyone will have a chance to be heard. Mr. Peterson, I see you raising your hand. Did you have a question?
Your Honor, correct me if I'm wrong. As of in the month of, I think around or about, about December 22nd, I believe there was an appeal filed to the Superior Court.
Are you saying you filed an appeal to the Superior Court?
I believe that's on the docket as we speak. Yes, sir. Yes, Your Honor.
Okay, well, if you've filed an appeal to the Superior Court, you're certainly welcome to do that, but there's no stay of this proceeding that's resulted from that appeal, so we're going to go forward.
Well, we're at the stay today, right? That's what happened. There was a sua sponte stay because there was an absentia in the last trial. Am I incorrect?
Let me just double check the docket. I didn't see any stay in place right now.
We'll continue stay. I mean, obviously you guys stayed the default judgment. The respondent was a no-show.
Oh, I understand what you're saying. So there was a continuance that was carried over to set the trial for today. That's not a stay of the proceedings. So this court has authority to proceed forward on a trial.
Your Honor,
are you saying you're not ready for trial?
No, no, Your Honor, I'm not saying that at all. I'm saying exactly what I mean. I filed what they call interlocutory appeal because there was a continuance order issued sua sponte due to an absentia. Okay.
No,
and
I saw that.
I had consultation to what your state law, your statute reads when the defendant's a no-show, it's a default judgment. I mean, you don't have the power to
yeah, so I'm not going to relitigate that argument right now. I saw that there was a continuance. I saw that there was a continuance. I saw there was an objection to the continuance. If you've filed an appeal, of course, you're welcome to do so, but that doesn't stay these proceedings, which means we can go forward with the trial now, unless you're requesting a continuance, in which case the court would consider that.
But if I file the appeal, you guys will lose jurisdiction, isn't that right? That's what the Supreme Court says. They wrote a letter back to me with respect to this case matter as well.
At the same time, so it makes it very hard for me to understand what you're saying. So, and also your microphone is a little bit tinny, so it's hard for me to understand you. So after I stop talking, if you can just tell me, do you want to proceed today, or do you want a continuance because of that appeal?
Can you hear me now? I'm taking off my Bluetooth.
That's much better. Thank you.
Okay, I apologize. It's the technology. The building that I'm in is the signals are very difficult. I filed the interlocutory appeal back in December. We did not meet any type of stipulation in mediation. I'm familiar with the respondent's practice out where I reside at, actually in California. She's involved or was involved in a federal case, and the same modus operandi was applied in that case, kicking the can down the road and playing with the courts. So yeah, I don't want to go to trial. I filed for the appeal with the Superior Court. The Supreme Court had issued a letter because I had went through the chain of command after your court, the Inferior Court, had filed the Superior Court appeal erroneously to your docket. Then in turn, I went to Division 2. Division 2 said, we don't handle this matter, go to the Supreme Court. I went to the Supreme Court. That's why I see the letter. That's the last thing docketed from my understanding, what I can see on your court docket. But yeah, I mean, this case had already been beyond the jurisdiction of your court after that no-show was there, because from my understanding, your RCW states for default judgments that if the defendant's a no-show within an hour and they don't get back to the court, it's automatically a default judgment. I mean, the judge, I've got the audio or whatever, the video from that recording, that hearing, he gave default judgments for other respondents that were at Sentia. I'm not sure why I didn't receive the same justice.
So I'm sorry, Mr. Peterson, if I could cut you off. What you've said raised a couple issues for me. Number one is, do you want to proceed with trial today, or do you want to wait and see what happens with your appeal?
I can. I filed an appeal. You guys, your clerk docketed a Superior Court or a higher court record onto your docket erroneously. They didn't send it over to the higher court in turn to, correct that particular error.
Sorry to interrupt
I
again.
don't want to try.
Peterson,
I did want one back in September or December, whenever this happened.
Mr. Peterson, if you could stop talking for just a minute. I'm not asking for a long explanation as to why. I'm merely asking, do you want to proceed with trial today, or do you want a continuance so you can pursue your appeal?
No, I want to adhere to the jurisdiction that's respective right now based on what I filed back in December.
Okay, so I'm not asking for a long explanation. What I'm asking for is, do you want to proceed with trial today?
Again, I'm saying no.
Okay, thank you.
This hearing has no jurisdiction at this point based on what I filed and what the state law is.
I understand that's not before me right now. So you're saying, no, I don't want to proceed with trial today, which means, are you asking for a continuance?
I am not asking for a continuance. I am asking for the appeal that I filed back in December. Your Honor, are you familiar with the record?
I've reviewed the record. What I would like to know is, would you like a continuance today so that this trial can proceed in the future or not?
No, this hearing doesn't have jurisdiction at this point.
I understand. If you don't want a continuance, then the court will proceed with the trial today.
But I already filed the appeal previously, so we can't do a trial. The trial would be at this. You're not the Superior Court, right?
The appeal does not stay these proceedings.
Okay.
You can ask the Superior Court to stay these proceedings, but it does not automatically stay these proceedings.
You would be correct to the effect, sir. And I thank you for you're right, because I did the interlocutor for the sua sponte continuance order. That's correct. We can go to trial if it's going to have an impartial hearing, but I mean, I'm at work right now, and I think I explained to you guys in all the filings and showed proof of what I do for work. I didn't even get a choice to, when I get, the prior judge had asked, when other plaintiffs or parties were available. He just scheduled it and didn't ask. And, that's very considerate. But yeah, I have a job, even though there's a federal shutdown going on. I'm a few years from retirement, so I got to hit post every day. I can't just go home.
I understand, Mr. Peterson. So, Mr. Peterson, there's one other issue I want to raise before we keep going forward with either continuing or going forward with the trial, which is, you'd mentioned that you had appealed and that it went to the Supreme Court, and you mentioned Division 2. I just want to put on the record so you know that I'm sitting here today as a pro tem judge. My normal everyday job is as a commissioner at Division 2 Court of Appeals. I don't recall seeing anything come across my desk from you. It probably went to a case manager or another commissioner, but there's a chance I've seen some kind of file of yours pass through there. With that said, do you have any objection to my acting as a pro tem in this matter, or would you prefer a different pro tem judge hear it?
I think it's a conflict of interest due to the fact that your senior case manager was the one who told me that they couldn't be bothered with it and to file it with the Supreme Court. So I believe that's a conflicting issue. Thank you for addressing that.
Okay, so you would object to my going forward with it?
I believe
understand.
so, because your coworker is the one who told me to file it with Supreme Court, and you saw Supreme Court's response was, we don't have a particular interest in this, and you don't have jurisdiction at this point. You have to go through the chain of command to the Superior Court. That's where your writ would be filed. And this was just information. Again, I mean, I filed the emails from your senior case manager.
I appreciate it. I'm just trying to limit the questions to one thing at a time. Ms. Abreu, do you have any objections to a continuance so that this can be in front of another pro tem judge so there's no questions about a conflict of interest?
Yes, Your Honor, I do, and I don't believe there's a conflict of interest. The reason why we're here today is because on December 19th, on the day of the hearing, requested a continuance because we were not served correctly with the actual court date, and two, I was in California for a different hearing, so I couldn't be here. The court granted my continuance. There was no default or there was no no-show, and he filed an appeal to the Superior Court when this case has not been litigated. There is no appeal to be filed, so that was wrong on his part. And then he went up to the appeals court, and they basically said the same thing because there is no writ to be handled because this case has not been litigated. There was no no-show, there was no default. The court simply granted my request for continuance, which is not unusual in a small claims case, again, because I couldn't be there due to other commitments. So I do object to his now motion because of a conflict of interest. I don't think there is one. There is no appeal pending in the appeals court at the moment. And I haven't heard from the Superior Court either. So I do object, Your Honor, respectfully.
Okay, I understand. Thank you. Mr. Peterson, just so we're clear, you're saying that you would prefer I not handle it. Obviously, I'm the judge that's sitting in small claims court today. So would you be asking for a continuance to a future date with a different pro tem judge?
I believe that I'm asking for the entire case, the proceedings to be set aside, because I believe that the prior issue needs to be cleared before there's any trial. That this thing is escalated. And the fact that you are a commissioner for the Division II Appellate Court, and the fact that the senior case manager was the one who told me specifically, and this is filed in the record. So you've got the copy of the email. All right. And they told me to go to the Supreme Court. So, I mean, that information, that's a, clerk error, but that's what brings us today. And, I am familiar with the case that the defendant's talking about. I'm familiar with the record, again, same modus operandi of the situation at hand. So I don't give any grace or anything
Mr.
like
Peterson,
that.
when I start talking, that's where you stop talking, not because of anything with me personally, but just out of respect for the court. In order to avoid any complications, I don't think there's any actual conflict of interest here, but to avoid an appearance of a conflict of interest, I'm going to recuse myself from this matter, and we're going to therefore have to go ahead and do a continuance. And this matter will be set to our next date will be May 8th at 9 a.m. And the parties will be required to appear on May 8th at 9 a.m. A remote appearance on Zoom is fine. And so this will be set aside until then, and the parties are both excused for now. Thank you.
Thank you.
Thank you, Anna.
Got the creepy crawlies, but they split the bill in two. 612.50 default judgment, what's a judge to do? Now Peterson's off the Bluetooth shouting, judge, you step aside. Ain't got no jurisdiction, my appeal is bona fide. Got a conflict of interest, gonna let this gavel rest. See you May 8th at 9 a.m., we'll put it to the test.